How are you doing, John?
Oh, busy day.
Busy
But
day. You're a busy fellow. You're a busy fellow. I enjoyed the last lunch and learn. That was very good.
yeah, well, I understand I today I've got one today, and Rebecca will fill everyone in on the next one, which is not hosted by me. Uh, so,
So
but it
you're a
sounds
very
very
good
interesting.
you're a very good teacher.
Mm,
You come by it honestly.
runs in the family, I'm afraid.
Runs in the family. I know. I know your mom is a teacher.
Yep.
But it was sure packed. It was very packed that last week or the last time. It was
Yeah.
packed with information. You have to have this 1 hour that you have to do everything in.
Oh, and we're a hard stop today, just so everyone knows. I have another meeting at 1. So
Right.
we are
Oh,
an
yeah.
absolute hard stop.
Oh, no.
Um,
No.
So as much as I enjoy, I can chat about this stuff till the cows come home.
Oh,
But
yeah.
uh,
Mm. Mm.
the,
Oh, no, but it's
um,
great. It's great. It's great that you do this. It's wonderful.
mm,
You have so much knowledge of your area.
mhm. Hello, Rebecca.
Hello, John, and hi, everybody. I had a connectivity issue, but I am delighted to now be in the meeting, and I wanted to thank John for being here, and with for his patience and really helping us get our CLE Lunch and Learn series started. So for anybody who has not already seen, we have a calendar we're developing with CLE Lunch and Learns. And we're excited to have you participate in those. And we're very grateful for John for doing our first two, actually. So thank you, John. And John, I'm not sure if you're able to share your slides.
I'm going to try.
Okay. And if not, then we can do that at our end.
Oh, you have to enable that for me before
Okay.
I can do it.
It's enabled. You should be able to,
Okay.
John.
Okay,
Perfect. Thank you. And
let me try.
I also wanted to say thank you, John, for making time for us in your schedule. And I understand that we do have a hard stop today, right at 1 p.m. Eastern time. So just to advise people that I will be the person at the Oscars starting the music right at about midnight. At about I was going to say midnight when everybody turns into a pumpkin, but we are turning into pumpkins at 1 p.m. So in that situation, I won't talk more and I'll let John get started. John, you've got everything's working now.
Yes,
Amazing.
you should be able to see my screen. And if you're
Yes.
not seeing the slides advanced, please someone shout out and let me know, and we'll see what we can do, because I think we had a delay last time. So welcome everybody from here, there, and everywhere. We have a presentation today on the law of medical consent and capacity to give medical consent in Nunavut. And this is a topic I present on a lot because, not surprisingly, as a government lawyer, one of my clients is the hospital and the Department of Health. And the information I'm giving you today is very much the information I give the doctors and the nurses, so everyone has the benefit of the same facts. So again, I'm a lawyer for the government. I have to give you a disclaimer. This is for educational purposes only. It does not count as legal advice. And the opinions, particularly if I answer your questions, and I'm quite frank about it, the opinions are my own, and they don't necessarily represent the opinions or position of my employer or the Attorney General, although I do my best to make sure that I align with the Attorney General, lest my continued employment. So where are we going today and what are we talking about? Um, so we're going to talk about consent to medical treatment. To keep this to a tight hour, we will not be discussing attorneys for property, guardianship, wills and estates, although that topic could fill, an afternoon. We're sticking mostly to healthcare, to medical consent for healthcare services, just because that's the way we keep this to an hour and to allow time for questions. And certainly my colleague Jennifer Hunt-Patra, who is the public guardian and trustee, has provided some input to this presentation as well. So I thank her for that in advance. So we're going to talk about consent to medical treatment and the elements of informed consent. We talk about substitute consent and exceptions. And we're going to talk about capacity to consent for adults, mature minors, and children, because that tends to be where the things break down. And I also have some tips on how things you could advise clients or things you might encounter around clients, and also how to protect you yourself as an individual. Because medical consent, one of the reasons I find this a fascinating topic is it affects everyone. Absolutely everyone. And we are all one bad day from not being able to speak for ourselves. And that's scary. But there are ways that we can take steps to make sure that our wishes and our wants are respected by healthcare practitioners providing us treatment and by people advocating on our behalf when we can't advocate for ourselves. And as lawyers, I mean, we sign up. Advocacy is job one. It's what we do. Yet, much like how so many lawyers don't have wills, many of them don't have advanced care directives either. And so we're going to talk about that. So we're going to move on to the introduction. In Nunavut, medical consent law gets complicated right away because we do not have a Healthcare Consent Act. We don't have a statute governing medical consent. So we also don't have legislation providing a relatively easy way to designate an advanced care directive or to designate a substitute decision maker. What we have is guardianship, which is very useful and quite important, but it is many of the other provinces and territories across Canada have come up with, for want of a better term, a more user-friendly way of providing the rights for somebody to make an advanced care directive that's recognized, that doesn't require the court's seal of approval, doesn't require approval of a judge. It is a way of designating a substitute decision maker or making an advanced care directive. Ontario, for example, has the Substitute Decisions Act. There's the Personal Directives Act in Nova Scotia. There's the Healthcare Directives Act. I think there's one for each of the Western provinces. It's largely the same. And we also don't have legislation respecting the creation of attorneys for personal care. Our power of attorney legislation, and I promise this is the only thing I'm saying about power of attorneys today, is we have attorneys for property. We don't have attorneys for personal care. So that is it's a legislative gap that we have to work within. And with the exception of involuntary patients under the Mental Health Act and represented persons, so people are represented by guardians, either a private guardian or a public guardian, under the Guardianship and Trusteeship Act, the common law is going to prevail. So I'm a government lawyer. I like statutes. I like knowing what the law is and what it says, and I like it being explicit. And the common law is a little too wibbly wobbly, but that is the world in which we live. So here, let's wibble through the wobbles together. And I apologize.
John,
yes.
If I may interrupt for a second, it's
sure.
Graham Steele here. Your slides aren't advancing again. I think you need to put it into presentation mode so that the slides advance.
All right, thank you, Graham. I don't know how to do that.
Top left, click on from beginning.
Yes. Everyone, are you seeing the slides? Can someone just give me a yay or a nay?
We see them, but they went back to not presentation mode. It might be easier to set your presentation mode and then share your screen.
Okay.
So unshare your screen, put it in presentation mode. So you click the from the beginning with the little play button.
All right, thanks.
And then share again.
Okay.
Thank you for your patience.
Okay, and so let us see if I can share here. All right. Let's see if this works.
That's working. Thank you.
All right, good. Thanks, everyone. And sorry for the delay. Well, let's advance quickly. So, wibbly wobbly, that's where we were. So, basic principles of consent law, whether it's in statute or whether it's in common law in this country. All capable adults have the right to determine what happens to their own bodies. They have the right to decide what medical interventions and medical treatments they receive. And as I tell doctors, the patient wins. in a dispute on what happens to their body. And patients have a right to make decisions that aren't necessarily what the doctor or nurse thinks is the best outcome. People have a right to make their decisions and make their informed decisions, and we have to respect them. Unauthorized treatment is a criminal offense and can also give rise to civil liability. So it is one time where you actually can go to jail and get sued if you provide unauthorized treatment without consent, or provide treatment without consent. Treatment requires informed consent, or in very rare cases, a court order. And in case healthcare providers suspect incapacity with an adult patient, one of the places to check to see if the patient is under guardianship is to contact the public guardian. Because even where there's a private guardian appointed, the public guardian will know, and they will be able to provide that information. So elements of consent. This comes out of a case from about 1980 in the Supreme Court of Canada called Millett versus Schulman. Consent is valid if it is voluntary. So coerced consent is not consent. Consent under duress is not consent. It has to be voluntary. It has to be given by a patient who has capacity, so they are able to understand what the proposed treatment is. We're going to talk capacity a lot today. The consent has to be specific as to the treatment and to the provider, and it has to be informed. So those are your basics for consent for medical treatment: voluntary, capacity, specific, and informed. And by the way, if you should ever find yourself in front of a healthcare provider and they hand you a consent form and they give you exactly 2.5 minutes to sign it, and not even giving you time to read it, if you disagree with things in the form, you're allowed to strike things out. You're allowed to make things more specific. You're allowed to write things in. And if you will do this, it means I'm not the only one doing that. So please help out. And they have to respect what you're consenting to. So consent is informed if, and again, this is out of the Supreme Court of Canada in various cases, if the patient receives sufficient information about the proposed treatment, its risks and benefits, the information about any potential alternatives, the practitioner's recommendation, and any other information that the patient requests. Basically, the patient has a right to disclosure. They have a right to know what is going to happen, because treatment without consent is assault. And at this segue, as someone who studies history, one of the reasons that this is a bit of a passion for me and why I'm really interested about it is, in this country, we have a horrible history of not respecting patient autonomy and not respecting individual consent. Some of our provinces really got on board with eugenics. And so, eugenics boards and compulsory sterilization, and that was not repealed until the 1970s in some places in this country. Indigenous people, of course, have been at the wrong end of the government and the heavy hand of the government. Up here, of course, tuberculosis boats and people being taken south to sanatoria are in living memory. So it's live and it's real that the state has not always respected patient rights and individual autonomy. And the courts, of course, have stepped in, and the statute law is very patient forward now on this. So it is, never get it out of your head that some of these laws exist because horrible things happened to individuals. It was until not all that long ago fairly common that if a woman went in for a lumpectomy or went in for a biopsy and they found cancer, they just did the mastectomy while she was out. No consent, no informed consent. You just wake up in recovery, having had this happen to you. There was an expose in the New York Times, again in the US, so slightly different laws, but in medical schools, quite often after doing the routine procedure that the patient consented for, they'd bring the entire medical students in and have them practice how to do certain exams. And again, overwhelmingly, these violations of consent and patient autonomy happen to vulnerable people and happen to women. So this is why, I never stop railing on about patient consent and informed consent. So again, if a healthcare provider has concerns about patient capacity, a good place to talk to is the public guardian's office. So for substitute consent. So informed consent happens when you yourself are able to give that consent. You're able to sign on the consent form. You're able to ask the doctor questions, or the nurse practitioner or the healthcare provider questions, and get answers. You're able to do your own independent research potentially. But what happens if you don't have the capacity? Either you are unconscious, or you're the affliction that you have means you can't speak for yourself. The common law recognizes the rights of adults and mature minors to make decisions for themselves, either on their own or with help, to set out their wishes respecting treatments in writing and to have those wishes respected, and to designate someone to make medical decisions for them if they become incapable of giving or refusing consent themselves. This is codified in most of the provinces and territories. There's a Healthcare Consent Act. There's a Personal Directives Act. In Nunavut and a few other places around Canada, it's still governed by common law, but that doesn't make a healthcare directive invalid. The Supreme Court of Canada, the various courts of appeal have said patients have the right to set out their wishes in writing. Again, Millett and Schulman, going back as far as 1981, but there's Ribel and Hughes, there's somebody in Metropolitan Hospital that I can never remember the first name of, but anyway, it was a case in Toronto. Healthcare providers must respect directions from a patient's approved substitute decision maker, whether that is someone they've designated or whether that's the private or public guardian, if there's a court-appointed guardian, and the patient's expressed wishes set out in an advanced healthcare directive. So healthcare provider has to accept the directions and expressed wishes. They have to abide by them. That is, otherwise, again, it's treatment without consent. So what's a substitute decision maker? They have a bunch of names, just so you know, across the legislation. It varies. Substitute decision maker, or SDM, because lawyers do love an acronym. There's substitute consent giver. That's the Mental Health Act uses that term, the current Mental Health Act anyway. And there are others that are healthcare trustees, healthcare, there are various advanced care directives. There's sometimes called living wills, or healthcare directives. Healthcare proxy is another word for substitute decision maker, all basically flavors of the same thing. But basically the common law comes down and says the competent adults and mature minors may designate their substitute decision maker in advance, in writing, or the court may appoint a private or public guardian. Naming someone as an emergency contact, because if you go up to the health center or the hospital in Nunavut, they'll ask you who your emergency contact is. That doesn't count as a designation of a substitute decision maker, nor necessarily should it. Because I like having an emergency contact who lives in Iqaluit, so they don't have to track down my family in Nova Scotia. A friend of mine is that emergency decision maker. I don't want to saddle that friend with making decisions about what happens to me if I am not able to give consent. I actually do want my designated person, which is my sister, to make those decisions. And where there's no advanced designation, the treating practitioner has a legal duty to inquire as to the existence of a substitute decision maker. And this comes up particularly with mental health. If someone has been involuntarily detained under the Mental Health Act, there is an automatic capacity assessment to determine whether the person can give consent on their own behalf. And if they do not have capacity, there's an obligation on the practitioner to locate a substitute decision maker. That will be changing slightly with the new Mental Health Act, of which I have one slide on toward the end of this presentation. And a substitute decision maker has a legal duty, it's a fiduciary-like duty, to act in the patient's best interests and according to their wishes. So if you're agreeing to be somebody's healthcare consent giver, substitute decision maker, you have to understand that your job is to execute the directions and the decisions that your trusted person is asking you to do, even if you don't necessarily agree with what they want. So an advanced care directive is valid. There is no magic form. And again, because we don't have an act governing this, there is no standard or prescribed form. And most of the provinces that have healthcare directive legislation don't prescribe a form. They prescribe contents of what it should involve or what it should include. But the Supreme Court of Canada and the courts of appeal in Ontario, British Columbia, Alberta, across the country have said a healthcare directive can be written on the back of a napkin so long as it is signed and dated and contains the necessary elements. There's no magic word. There's no magic form you have to use to make something official. So a directive is valid if the maker of the directive is a capable adult or a capable mature minor. The directive's in writing, it's signed and dated, and the directive sets out the maker's wishes respecting medical treatment. That's it. They can be really basic, and healthcare providers must respect the advanced directive. A really simple example of an instruction or advanced instruction is if you have serious objections to certain vaccines, or either an allergic reaction, severe allergic reaction, or you have a philosophical or moral or religious objection to blood transfusions or to any medical interventions, a lot of people carry a card in their wallet with that instruction, and that's an indication that the practitioner has to respect your wishes. I once worked with a healthcare policy analyst in New Brunswick who said, "I'm allergic to sulfa drugs. I want everyone to know." And you'll see even some people have their allergies and whatever, they get a tattoo with that on it, just like Mad Max. But again, you want everyone to know. I don't want there to be any ambiguity. So generally speaking, the law does not allow substitute consent except where ordered by the court for certain very invasive and very intensive procedures. So any psychosurgery, any electroconvulsive therapy, any removal of living tissue for donation or transplantation, no sterilization without consent, folks, and no treatment that is primarily for research purposes, or, and the criminal code is very explicit on this, there can be no substitute consent for medical assistance in dying or MAID. The court would have to order authorization for any of those invasive procedures. So there is an exception to consent for emergency treatment. And healthcare providers can render emergency treatment or assistance if they have no reason to believe that the patient would refuse, if the treatment's necessary to preserve the patient's life and health, and if there's insufficient time to locate a substitute decision maker. This is the break glass in case of emergency. It's the life or death situations. And it is one of those situations that if a treating practitioner has any evidence that a patient would not consent to a specific thing, such as if you have flagged and put it in the healthcare record that you have a do not resuscitate order, which is a form of advanced care directive, the practitioners are going, when they pull up that file on the advanced health, on the medical record, say, oh, there's a DNR order, and then they take the paddles to you like it's Grey's Anatomy. That's a violation of your rights, or of the patient's rights. So I've been singing the praises of advanced healthcare directives. It's my obligation as the lawyer and as your friendly teacher for today to tell you that there are some issues with advanced care directives that come up and across the country, and the case law follows on this. The big one is they aren't specific enough. And the strike against them that the doctors who represent the Medical Protective Association and the Nurse Protective Association and the other bodies that represent doctors and healthcare authorities say that most lay people can't possibly make instructions about anything that might ever happen to them ever in the future. So directives can be hopelessly vague sometimes. For example, quite often you'll see no heroics. No heroic measures. Well, what does that mean? Do not resuscitate does not mean do not treat. Do you want artificial hydration or nutrition? You want no heroics, no shock, like no, do not resuscitate, but do you still want to be kept on a drip? Do you want to be moved into palliative? What do you want? This is, again, an advantage to naming a substitute decision maker because they can fill in the gaps. And they have a fiduciary obligation to act in your best interest. Another problem with advanced care directives is that they're out of date. People's views change over time. And as they get older, people's views tend to change about what they want. Or we witness a parent or a friend or a relative go through something and say, oh, that ain't never happening to me. But we never get around to updating our own documents. Lawyers are notoriously bad at taking their own advice. This is why so many of us don't have wills and so many of us don't have up-to-date healthcare directives. It's a very responsible thing to do. And also people are scared of having the conversation about death and dying. And there's the human nature that our desire is to live and our desire is to think, oh, that's going to happen someday. But again, we're all one bad day from this happening. Or sometimes this happens, they name a substitute decision maker who's unable or unwilling to act. And unable just mean they're not in the country and you can't reach them. Unwilling means, I'm sorry, my mother named me a substitute consent giver and I really don't have the capacity to do that. I just can't. So again, and there isn't a backup named in the directive as to if this person isn't able, then someone else. Or they name more than one substitute decision maker and they can't agree. This is a family kind of thing. You name all the kids as the substitute decision makers, and the kids have vastly different ideas, like adult children, I mean, and they can't agree on what's best for their parent. And it just leads to this decision-making limbo where nobody knows what to do. Or here's a big problem with advanced care directives: they can't be located. You have one, it's in a drawer somewhere. It's in the junk drawer with the little packets of ketchup, or it's in the bank in the safe deposit box next to the will, or who knows where it is. One of the best pieces of advice I ever got on this actually came from a first aid course from the Red Cross, and it was, if you have someone named as an advanced care directive or as your substitute decision maker, put it in your phone. We all carry phones now, pretty much. Put it, like, in case of emergency, contact this person, put it in your contacts. Have a PDF of that advanced care directive. There are lots of very forward-thinking healthcare systems in this country who actually have a tab in the electronic health record for care planning, and they might be able to add it into the system, or you can make a flag like in Meditech, which is what the GN uses. There's a system you can make a note, you can flag about that. So again, if you can't locate the directive, it's not much good to you. So that's the basics. Let's talk about capacity to consent. And again, capacity on consent to medical treatment is based on a certain number of presumptions. The age of majority in Nunavut is 19. So anyone 19 years of age or older is an adult. Anyone under 19 is a minor. Let's define the terms. Adults are presumed capable of giving and refusing consent. The presumption is in favor of capacity for all adults. But if a healthcare provider knows that a person is under guardianship, they can't rely on the person's consent without first consulting the guardian. So if they know a person is under guardianship, if there's a court order, there's an appointment of a guardian, they have to consult with the guardian first. Minors under 19 presumed incapable of giving and refusing consent. But as we all know, maturity is a continuum. And there are some minors who are quite mature. Some minors require quite invasive and scary health treatments in their own behalf, and they've reached the level of maturity where they get to make those decisions on their own. And that's called being a mature minor. And there is only one province defines mature minor in law as 16 and over, and that's New Brunswick. It was a uniform act that didn't turn out to be all that uniform, because only New Brunswick enacted it. But presumptions, all these presumptions are rebuttable. Again, they're presumptions in favor or against capacity. So all presumptions about capacity are rebuttable based on the available evidence, based on underlying medical condition, changes in that medical condition, the healthcare provider's professional judgment, healthcare provider's assessment. And again, anything the court has already ordered fits in that as well. And decisions about capacity are ultimately decided by the Nunavut Court of Justice. We do not have a consent and capacity board, as they do in some provinces. And in some provinces and territories, they designate the public guardian and trustee as the substitute consent giver of last resort. If there is no one else available to ask, it kicks to the public guardian. In our territory, the public guardian would have to apply for an emergency guardianship order first. There is no sort of automatic right to be a substitute decision maker. But it is sort of a last resort, but it's not as easy as it is, or not as simple as it is in some of the other provinces. So for adults, age of majority is 19, presumptions in favor of capacity. And if an adult loses capacity, consent can be given by their substitute decision maker or a court-appointed guardian. And if an adult permanently or temporarily loses capacity, there's also guardianship, is the route that we have to go. For mature minors, this is where healthcare providers want to throw things at me, because they would like things to be, like me, they like things to be concrete. They like to know when somebody becomes a mature minor, what age, what date, put it on the calendar, and then I don't have to have this question anymore. Unfortunately, we all mature differently, and we all mature at different rates. Girls tend to mature faster than boys, for example. There's no set age when a minor becomes mature. Typically, we start asking the question about mature minor status around 14 or 15. 16 and higher, you tend to lean closer to favor of capacity. A court in Ontario in the Hamilton-Halton region recognized someone as young as 12 to be a mature minor. But that was a particularly mature 12-year-old. And the court made pains to say that. So a healthcare provider determines capacity on a case-by-case basis. It's always an assessment, and you can have potentially capacity to make decisions about one thing, but not about another. Again, it depends on capacity. So if a healthcare provider determines that the minor has capacity, then they have the same consent rights as adults, and they get treated like adults. Healthcare providers must respect the mature minor's wishes, even if they conflict with parents or guardians. And the criminal code has a hard prohibition on mature minors with respect to medical assistance in dying. I suspect that will be found unconstitutional at some point, but thus far no one has challenged it. Mature minors cannot consent to medical assistance in dying. Medical assistance in dying could be a whole other presentation. So if you're interested, let me know. With minors, so anyone under 19 who isn't a mature minor, presumed to be incapable of giving or refusing consent. So in most cases, if a minor is unable to consent, their parent or their legal guardian consents on their behalf. And if a parent or guardian refuses to act, or they're unable to act, the last case, break glass in case of emergency option is for the Director of Child and Family Services to exercise their authority under the Child and Family Services Act to temporarily take the child into care and make healthcare consent decisions. And again, no medical assistance in dying for minors. Hard prohibition in the criminal code. So finally, before I hand it over to if there are any questions, we're going to talk about some protective factors, some things you can do and things your clients can do. Put it in writing, make a healthcare directive. There are great templates available. I like the one from Manitoba Health. It's well written. It's quite straightforward. Ones for Ontario would also be useful, particularly if you live in the Kikatani region where you're, worst case scenario, you're being medevaced and you might find yourself in the Ottawa hospital. Because as soon as you leave Nunavut, you're subject to the consent law of the province you're sent to. So there is a Healthcare Consent Act in Ontario, and there is a Substitute Decisions Act. And there's one in Manitoba where we refer people from the Kivalik. There's one in Alberta where people get referred from the Kitikmeot. So it's good to, a good rule of thumb might be to make sure your healthcare directive complies with what the law in Ontario says. This is one of the reasons, by the way, I keep my Ontario license valid. It's because enough healthcare patients get referred to Ottawa from here, and I advise the hospital that I do have to give advice on the laws of Ontario. 99.999% of my practice is on the laws of Nunavut, but it's the healthcare law and that reference to patients in Ontario that it's worth keeping my license active because I am allowed to give legal advice on the laws of Ontario. You may need to refer to a colleague or to another lawyer who is licensed in that jurisdiction to give advice on the laws there. Make sure people know about anything they need to know about your health. You don't need to tell the world. I mean, I know the Privacy Commissioner's online, so you do have a right to control your private information, your private personal information. But if you're designating somebody to be your healthcare director, your advanced healthcare person, your substitute consent giver, substitute decision maker, make sure they know what you want. Make sure that they know about any underlying medical conditions or allergies, any deeply held beliefs you have about medical treatment, any wishes respecting organ and tissue donation is also, they should know about. Designate a substitute decision maker. And when choosing, choose carefully. Pick someone you can trust, someone who can act in a crisis, someone who is the person in your life who is a good port in a storm. Someone who will respect your wishes, even if that means they're, might have to get into a bit of a heated argument, shall we say, with other people in your family who may not share said wishes, who will seek information and support from your close family and friends, who will be the interface between you and the healthcare system, who will be there to speak for you when you can't. Tell your healthcare provider, and again in Nunavut, because we never have the same doctor twice, that's what the electronic health record is for. Make sure your doctor knows you've got a healthcare record. They can scan and put things into Meditech, and don't let them tell you they can't. Don't try to bluff the person who writes your contracts, folks. And also have an in case of emergency contact on your phone or on the device you carry around with you, or a card in your wallet if you want to be old school, just so people know who they're supposed to contact if you run into trouble and can't provide the information yourself. It's just some smart things you can, simple things, cheap. Some of these things cost no money that you can do. So I mentioned the Mental Health Act earlier, and we are going to have a new Mental Health Act. Part of it is in force already. You may have seen the call out from the Law Society because the Department of Health is seeking lawyers who don't work for the government of Nunavut, who are interested in serving on the Mental Health Review Board. There's going to be a board. It can't really be created, and this act can't be brought into force until we have the board up and running, appointed and trained. And the board has a good mix of local people, community elders, respected people, lay people, and practitioners, professionals, lawyers, psychologists, medical doctors, etc. So there's a mix. Nunavut Tungavik Incorporated is taking the lead on nominating the lay members. So if you know someone in your life who would be awesome at this, direct them to the information in that mail out. It's Opal McInnes at NTI. But if you are a lawyer, I know some of you are, most of you are, if you want, and if you don't work for the government of Nunavut, and you want to be on the Mental Health Review Board, contact the Department of Health with your resume and your information, because you will be doing a lot of really good work for Nunavut. But for our purpose today, soapbox over, folks, substitute consent givers, the definition of the term in the Mental Health Act, is going to be replaced with a new term, a new person, a new role called Tikio Tauyit, or Tikio Tauyuk is the singular. So it means selected representative. And this person will have the power to make medical decisions for an incapacitated person, but will also, their role is to be the interface with family, to speak for the patient, to be the go-between with family, to get information. It's a much more expanded role. It is something that our community consultations told us would really be beneficial and would really make the system more holistic and more trauma-informed and more culturally safe. And it is very similar to the system used in New Zealand with Maori. And when we showed them that model during the community consultations, the Elders Committee just said, we've been telling you to do that for years. Do that. So what we came up with the Tikio Tauyuk, it's a great idea. I encourage you to go on the Nunavut legislation website, read the new Mental Health Act. It's one of the things that I'm most proud of having been part of as an advocate for mental health and as a lawyer in this government. We're putting our Mental Health Act, which we inherited from NWT on division, in the shredder, and we're replacing it with something new and fashion forward and very respective of Inuit cultural principles. So I'm very excited about it, but it can't come into force until we get that board up and running. And the board will have power to determine questions about capacity for mental health clients, not for general primary health care. So that's it for the informed the part of the presentation today. I'm happy to take questions if you have any. Now's the time to ask, or if you're the type of person who thinks of the question you want to ask 20 minutes from now, send me an email or give me a call. I can't give you advice about individual clients unless you work for the Department of Health, but I'm happy to provide information or links. This is a topic that I speak about with a certain degree of passion. So I'm happy to have that conversation with you. So I'm going to stop sharing my screen, and I'm happy to hand it over to Rebecca to moderate any Q&A there may be.
Great, thanks so much, John, and I'm happy to take questions. You can raise your hand, or you could put it in the chat if you have questions. It looks like we have one in the chat. The question is, in the absence of STM legislation in Nunavut, does the common law apply, or is it entirely in the realm of presumed consent?
The common law applies, and the common law speaks about so what the principles I talked about in the slides are all common law principles that have been codified in Ontario and Manitoba and other provinces and territories. So it's the common law principles. The exception is involuntary patients under the Mental Health Act. Involuntary patients, there's a prescribed procedure in section 19.1 and 2. So that's coming out of that, and the new Mental Health Act replaces those substitute consent givers with Tikio Tauyuk, and there's a procedure around consent for minors hardwired into the new Mental Health Act. So to answer, there's another question in the chat, and then I see Paul Falvo's hands up.
So the next question in the chat is from Graham Steele. What is the source of the law on mature minors? Is it common law or is it statutory?
With respect to right now, it's entirely common law. In Nunavut, it is codified in other places. Some provinces, notably Ontario, there is no age of consent. It is all capacity based. But when the new Mental Health Act comes into force, there are specific provisions around mature minors that are codified into that act. So an advanced healthcare directive is all common law as well right now. And guardianship is statutory. I think that goes without saying.
Okay, thank you, John. The next question was from Paul Falvo, and then I'll go back to the chat.
Yeah, John, thank you for making this so interesting. I had no idea when I woke up this morning that this was such an interesting topic. Most of my professional life has been in criminal law, but in a previous incarnation, I was a firefighter and a first aider, and it had been drilled into us that consent is assumed when a person loses consciousness. But am I right? I'm given to understand what you're saying today, that if somebody has said, for example, that they object to a particular treatment, they're declining help, that could continue when they become unconscious.
That is largely correct. So as you say, the presumption is in favor of life unless you know otherwise. So first responders, firefighters, so emergency medical technicians, advanced care paramedics, emergency room doctors, do what they do, and they try to save your life and they try to keep you alive. However, if you're coming into a house and the person's in a palliative care situation and there is instruction that no, do not resuscitate, doesn't mean you don't treat, but it means you don't shock or you don't provide CPR, for example. You act on the known wishes. Also, if you know, because the person is carrying a card or they have information saying no blood transfusions and you provide them a blood transfusion, that's assault. So, and that was a case that it was in Ontario, it was a Jehovah's Witness who the doctor, in that case, the doctor knew that the person, but gave them a blood transfusion anyway. Emergency room doctors, because they never see you again, God willing, they never see you again. They only see you once. They don't have your entire healthcare history necessarily, particularly if you're on vacation and you're in some other place, which is why you have that thing in your phone. But you rely on, so yes, if there's a certain degree of assumed consent or emergency treatment without consent, unless you have any evidence to understand otherwise.
Thank you. We have a question from A. Crawford. Can you provide a link for the proposed Mental Health Act? I don't know if you have
Sure.
that available. Okay.
Yes.
And the question is what the timetable is.
Oh, for implementation. The goal is next year, 2025, is the latest I heard. I think that's what the Minister of Health told the Assembly. So we're going to do our best to make it happen. I'm pulling up a link as I'm chatting. So if Rebecca, you've got any more questions, I can do that while I'm searching.
So why don't I, as you're doing that, and John, thank you for being so multi-talented and working with the technology here. I appreciate you. I have a question from Megan O'Brien. In terms of process, in the case of a valid advance directive, does a substitute decision maker still need to provide consent? Which would of course have to be consistent with the person's prior wishes as indicated in the advance directive. And just so you know, John has posted the link. So John, were you able to hear that question?
I'm reading it now. So
okay.
The advanced care directive will prevail. And if there's a gap, they would go to a substitute decision maker is typically how it works. So if there is the patient's prior wishes expressed in a validly enacted directive are going to apply. And if there is a question or if the directive isn't specific enough to the type of treatment or type of thing, that's when you would sort of default to a substitute decision maker, or if the condition changes and that change is not contemplated in the directive.
Okay, thank you. We have another question in the chat. It's from Jessica Chaptai. Under the Mental Health Act, I had trouble identifying who could make a determination of incapacity. Can any healthcare practitioner make this type of assessment, or is it limited to, say, physicians and nurse practitioners, but not RNs, for example?
Yes, it is. The current act says medical practitioners, which is defined in our legislation as a doctor, as an MD. Now, anyone who lived and worked in Nunavut knows we don't have doctors in every health center. So what typically happens is the mental health nurse or the treating person in the community will confer with a medical doctor at the hospital or another place. There's also possible to do assessments by telehealth. if the practitioner is sufficiently confident that they're able to get enough information through telehealth. It used to be there was a hard line against anything but by telehealth in this regard, but then COVID. Under the new Mental Health Act, it will be broadened because we now have mental health nurses who are registered psychiatric nurses who are going to be registered and licensed by the College and Association of Nurses of the Northwest Territories and Nunavut. Used to be Renat-New, now called Can't-New. They are going to be licensing those mental health nurses and psych nurses in Nunavut, starting as well, the act's in force, so it will be coming very soon. But under the new Mental Health Act, we broadened the capacity to the people who have the medical or the education to be able to do those capacity assessments. But right now, because the act is from 1967, it still says medical practitioner, which means doctor. So I think it will be broad. I think it's safe to say it's going to be broadened to NPs, to nurse practitioners, and to psych nurses, but probably not to RNs. But that will be up to the regulations. Stay tuned. Watch the Nunavut Gazette, because as I know you all do. Everyone's favorite publication.
And it looks like those are our questions, although I'm scanning. I do want to say I appreciate the number of questions. It's always much more interesting when people are active. And John, thank you so much for your engagement with all that. Oh, here's another question. Which portions of the new Mental Health Act are in force?
Just the part that establishes the board, because the board has to be a thing in order for the minister to appoint people to it. But as there's been a call out, I know Nalini posted it to the Law Society website. And again, the community lay people, lots of us on this call work with wonderful people across Nunavut who may not have a professional designation after their name, but they're exactly the kind of person you want on the Mental Health Review Board. If you know someone and they're willing to serve, kindly direct them to NTI and say, I would like to be nominated on this board. And if you're a lawyer who's interested and you have some time to participate and you're interested in making an impact in the mental health law of Nunavut, again, put your name forward and you would be contacting the Department of Health. Kim Parody at Department of Health is accepting those applications. The information's on the Law Society website. There was a call out for that. So definitely look for that. And I obviously can't serve on this board because I work for the government of Nunavut. I represent the minister, so it would be, we're all GN lawyers are conflicted out, so we can't be on the Mental Health Review Board, but I know there are lots of people out there who might be interested and are available to help. And certainly if you know psychologists and psychiatrists in your life who are interested in doing this kind of work, obviously the preference is for Nunavut residents, but we are certainly, the minister will consider applicants from outside of territory as well, so long as you're licensed to practice here. So anyway, I have no role in appointing anybody. It's entirely up to my colleagues upstairs at Department of Health. But this Mental Health Act, we took the recommendations from the suicide inquest, the systemic inquest into suicide. We took hours and hours and hours of community consultation, of expert consultation. The Legislative Assembly had some fantastic feedback on it, which we incorporated. This is going to be among the best mental health acts in Canada once it comes into force. So I'm excited. Again, one of the things that when they tell you when you enter government work that they don't tell you is that you get to help change the law, and if something doesn't work, you can change it. This is it's been fun. It's been a pain. It was a 10-year process, so nothing happens in government quickly. But if you don't like what you got, you actually can change it. Trooper was right. And again, I certainly hope we have a healthcare consent act at some point soon. I don't know that it's on the radar, but it is something that we at Department of Justice continue to be in favor of. So we hope our friends upstairs at Health will take us up on that someday. But you now have the same information that I tell the docs and that I tell the nurses. I do very much this presentation a couple of times a year with the mental health nurses, with the doctors and the nurses and the nurse practitioners. And I'm the guy at the end of the phone who answers their panicky questions about interesting and weird medical consent questions. So I am happy to take your questions as well, either right now or going forward. So thank you very much. This has been fun. I know I'm going to be back in front of you on a Lunch and Learn sometime soon on probably a topic another thing that I'm very good at. It'll probably be a privacy related presentation. So we'll talk about that sometime soon. Watch this space. But Rebecca, I know there are other presentations coming up, and I know you're giving one of them. So this might be time to shamelessly plug.
Well, thank you, John, and thank you again so much for doing this. We do have a calendar that's now up on the website and is being distributed in e-news with respect to what our upcoming Lunch and Learn sessions are. And I'm actively seeking to coordinate a diverse range of presentations, some by John, not all by John. And
Thank you. I have to practice law at some point.
Has things to do, but we really appreciate you, John. Thanks so much.
Okay.
And if there are other people who are interested in delivering CLE and giving back to your peers in this way, it is a labor of love, by the way. We do have some swag, but it is a voluntary endeavor. You can get in touch with me, and I'm actually going to put my email in the chat. If anybody wants the slides or wants to get in touch with me about the CLE programming with the Lost Society of Nunavut, please do. Always happy to hear from people. And yes, I will be doing a presentation myself, but there will be others as well. So again, thank you, John. It looks like we are letting you go to your next meeting.
All right, thank you. Now I get to talk about construction projects for a while. All right, thank you, everyone.
Thank you again. Very much appreciate it.
Always nice to see everyone from across the bar. So so thanks very much. I don't be a stranger, as I always say. All right, thanks, everyone.
Thank you.